The division bench, in the facts of the said case, held that the appellant who was a complainant was not a victim who was entitled to prefer an appeal under Section 372 of the Code and, therefore, she could not prefer an appeal under Section 372 of the Code in the police case. According to the division bench, even otherwise, if the appellant was supposed to be covered by the definition of victim under subsection of Section 2 of the Code, having a right to prefer an appeal against the order of acquittal, according to the division bench she was required to file an application for grant of leave to appeal. The division bench further pointed out that even against an order of acquittal passed in a case instituted upon a complaint, the complainant has been provided the right to appeal, and he can file such appeal with an application for grant of special leave to appeal from the order of acquittal. Thus, under the Code, the division bench proceeded, the appeal against acquittal could have been preferred only with the permission of the High Court, on an application filed for grant of leave to appeal against the order in appeal, according to the division bench of the said High Court. The proviso to Section 372 of the Code gives a right upon the victim to prefer an appeal against the order of acquittal being sufferer from the act or omission of the offender, but such appeal shall lie to the court to which an appeal ordinarily lies against the order of conviction of such court. The division bench further held that by the proviso, a right to file an appeal has been conferred on the victim against the order of acquittal, but the procedure for filing such appeal will be the same as provided under Section 378 of the Code. The appellant was the father of the deceased, who got married with the respondent number 2. It appears that the appellant filed the appeal against an order of acquittal by taking aid of the proviso to Section 370 to read with Section 378 of the Code, claiming to be a victim. A question was raised as to whether the father of the deceased could be said to be a victim. The division bench held that in view of the amendment with effect from 31st December 2009, a limited right to the victim to file an appeal against the order of acquittal was of course given, but such right could not be conferred in case of an offense which was committed prior to the date of incorporation of the said proviso. In that context, the division bench held that right to appeal of the petitioner had accrued only after the decision in the sessions trial where the respondent number 2 and 3 were acquitted on 30th September 2010 and the petitioner was, thus, entitled to prefer an appeal. The division bench further held that the father of the deceased was also a victim within the meaning of subsection of Section 2 of the Code.